First case will be Michigan Gun Owners versus Ann Arbor Public Schools. Please proceed.
Good afternoon, Your Honors. James Mikowski appearing on behalf of Michigan Gun Owners Incorporated and Ulysses Wong. I'd like to reserve 3 minutes for rebuttal.
That would be fine.
A public school cannot be allowed to subvert and usurp the law, and that is precisely what is happening in this case. We are asking this court to reverse the opinion of the Court of Appeals and find that school districts lack the ability to regulate conduct otherwise permitted under state law, to wit, the non-concealed carry of firearms by licensed individuals with legitimate reasons to be on school property. It is appellant's position that school districts are not preempted under MCL 123.1102. The examples of local units of government enumerated in the statute share one thing in common that school districts lack: the ability to pass ordinances criminally punishable under the law. School districts do not in any way have such authority. Instead, the school districts are not only direct state actors, but are also agents of the state. Appellee is circumventing MCL 28.4250 by misusing Ann Arbor City Ordinance 9.64 and MCL 380.11A3B to threaten lawful licensees with criminal trespass prosecution. In its opinion in this case, the Court of Appeals superficially analyzed the laws regarding firearms in schools. Much emphasis was made of the term weapon-free school zone as set forth in MCL 750.237A. The Court completely ignored MCL 750.237A5C, which exempts valid concealed pistol licensees from the provisions of the Act. The so-called Weapon-Free School Zone Act is thus not applicable in the case before your honors today. MCL 28.4250 limits the concealed carry of firearms.
Counsel, good morning and welcome to the Supreme Court. And I guess what I would love to do, if it's okay with you, is I want to go to kind of the core issue of kind of the case that's presented to us. If you look through the statute, it's very clear. It says village, township, city, or county. And I guess the question I would have for you is going kind of to the heart of this. If you're looking at these four elements, and we are by nature a strict constructionist court, would we not have to kind of create in order to allow for your argument to be successful?
No, because the doctrine of field preemption still applies. And under the Llewellyn analysis, the issue of firearms in schools has been examined in several different occasions: MCRGO versus City of Ferndale, Capillary District Library versus Michigan Open Carry, and the courts have consistently ruled that firearms rules are preempted under state law because there's a comprehensive licensing scheme, a comprehensive regulatory scheme in the state. So they're not directly preempted under 123.1101 et sec. However, the doctrine of field preemption still applies. But it's our position also that they are direct state actors. A city, township, county, or village all have the same thing in common. They have the ability to write ordinances that are punishable by criminal misdemeanor.
But counsel, if I were to look at field preemption and kind of going with the analysis that that you're putting forth, doesn't a school district have its own elected board, and ultimately doesn't the superintendent then report to the board? So isn't, for all intents and purposes, the Ann Arbor Public Schools separate from the City of Ann Arbor, because the City of Ann Arbor isn't able to govern the school district? Isn't it a separate entity with a separate electoral process, with a separate board, with a separate kind of implementation plan, in the sense that the superintendent of the Ann Arbor Public Schools is responsible to the board, and the board is elected by the people, but the two aren't connected in terms of the City of Ann Arbor and the school district?
The school district is an elected board by the local citizens, but they ultimately report to the Michigan Department of Education and the state of Michigan School Board Authority. What the Ann Arbor Public Schools has done, though, is they're co-opting the City of Ann Arbor, which has passed a local ordinance with regard to disruption in schools, using that local ordinance in conjunction with their powers to prohibit certain people from being on school property and threatening people with criminal prosecution where they would not in and of themselves have that ability.
That sounds like a conflict preemption argument, counsel, not a field preemption argument. Do you think you have a better conflict preemption argument than a field preemption argument?
I think the field preemption is key here because they lack the authority to regulate this behavior. The statutory language is quite clear that the Weapons-Free School Zone Act simply doesn't apply to anyone with a concealed pistol license. So we go into the exceptions that are contained in 28.4250. And it's quite clear, the legislature has written that you are not allowed to carry a concealed firearm in any of these locations.
I follow the work of, of reading all the statutes, but it sounded to me like what you're saying is that the public schools are, by virtue of using the trespass statute, are creating a conflict with the state law. Is that fair to say?
And that is potentially true, because again...
But that's a different kind of preemption. That's conflict preemption, not field preemption.
Right, and we've not briefed that issue. If the court would like me to brief the issue of conflict preemption, I certainly can as a supplement.
Well, is it an issue you've raised and pleaded throughout your litigation?
I have not.
Okay. But to the extent it's an issue, help me with understanding what the conflict is. I mean, there are lots of things that are not illegal, but I could still have a policy saying don't do it on my property, right? I mean, it's not illegal to chew gum, but I might have a policy that says don't chew gum on my property. And where's the conflict there? Because
the punishment is, the city of Ann Arbor is going to arrest you for trespass if you're chewing gum and they tell you can't chew gum. And chewing gum is not a protected right under the statute. Under the statute, you have the right to carry an unconcealed firearm in these locations. But I mean, as a matter of doctrinal, categories, the conflict is not between the policy and the state law, right? You need to loop in the trespass to create the conflict. Is that right? Yes. Okay. So it's sort of conflict preemption with a little bit of an angle, maybe. Good way to say that, Your Honor. Okay.
What are we to make of the work being done down the street? There's a bill that was introduced in the Senate, and it's out of the Senate now in the House, that specifically addresses school districts, intermediate school districts, community college district, public libraries, local authority created under state law and any other political subdivision of this state. They're going to include that language in the definition of local unit of government. This is a court that has gone to great lengths to express, in our opinions, our respect for the separation of powers. And you're asking us to interpret a statute and through the use of field preemption to read something into the statute that's not expressly there. Yet down the street they're working on a possible amendment to the statute. What are we to do with that?
If the legislature wishes to change the law, that is certainly within their province. That's our whole position throughout this case. In 2012, Governor Engler was presented a bipartisan bill to allow concealed carry in schools with additional training for anyone who wished to receive that training. However, it was vetoed. The legislature should be addressing this issue, not the school districts themselves. The school districts themselves have gone beyond what the legislature has allowed. There's been various bills that have been put through the House and Senate with regard to concealed carry or unconcealed carry or allowing firearms or banning firearms. Let the legislature work out this problem. The statutory language that's before this court is very clear.
So what are you telling us to do here? Will you make that very clear? What is the status of this legislation in the legislature, and what would you have this court do in response to whatever that status is?
I think the court needs to look at the plain meaning of the statutes.
No, I'm asking about the legislation. I mean, what would you have us do with the legislation that's apparently pending in the legislature? I mean, this is a very time-consuming, resource-heavy case. And if the legislature is going to do something contrary to what this court might decide, we might want to know that that's a likely prospect.
And I don't know what the legislature will do, and I don't know if the legislature does change law, if Governor Snyder will will sign it or veto it. However, I think that we need to defer to the legislature, and the legislature has made it quite clear. This court is...
Defer to the legislature in terms of what it's already done, or defer to the legislature in what you think it might do tomorrow?
We have to defer to what the legislature has already done, which is create this section of the law which allows for the unconcealed carry of firearms on school property. I think we need to defer to, I would ask the court to defer to the legislature with the clear legislative intent. There's always a presumption that the legislature knows exactly what they're doing when they write a statute. If the legislature somehow feels that the statutory language is not what they intended, that's up to the legislature to fix, not up to a local school board, and not up to the Court of Appeals. I think what we are asking is to defer to the plain language of the statute. And the plain language of the statute allows...
But thus far you've been talking about preemption largely. Are you trying to defer to the statute, or is it some sense of occupational or field preemption that you're most concerned about? I'm really getting confused very quickly what it is you're trying to focus on.
The legislative analysis of PA 387, which was codified as MCL 123.1101, made it quite clear that the legislature was concerned about a balkanized patchwork of laws where something would be legal in one area of the state, whereas it would not be legal in another area of the state. And that was why the 123.1101 et seq was passed, to make sure that we had a uniform set of laws across the state. The legislature never addressed school districts. They addressed local units of government, cities, townships, counties, et cetera, because those are the authorities in the state that have the ability to make laws. School districts don't even have that authority. They lack that authority. But they are allowed...
But wouldn't this have just been easier if the legislature had actually imposed the word school district? Then you'd be able to have a plain meaning, strict constructionalist, conservative argument. I guess the question I have is that it didn't. It was very clear the legislature was, and again, you're doing an excellent job, so I'm just asking you these questions because I want to have a better understanding. But the legislature kind of was very specific in terms of what it said. And so the challenge for this court is you're asking for this court to go beyond the specific words of the legislation.
No, I'm not, because what I'm asking the court to do is to just look at the strict construction of the other statutes that have to be read in peri materia. When you read the statutes, there's quite clearly the ability to carry on school property by a licensee unconcealed. Now, if the legislature wishes to address that, by all means, that is their province. They should be addressing this if that's what they choose to do. However, that's not what the state law is. The doctrine of field preemption has been in place for well over 20 years, I believe. MCRGO versus City of Ferndale, Capillary District Arbor versus Michigan Open Carry have both found that firearms regulation is subject to field preemption, and that the state has taken unto itself all of the power to regulate firearms. Now we have an entity, these school boards, that are trying to usurp that authority. That is not what should be happening, and that's not where we should be at. Justice Gorsuch said last year, if a statute needs repair, there's a constitutionally prescribed way to do it. It's called legislation. And judicial tinkering with legislation is sure only to invite trouble. What the Court of Appeals and the Washington County Circuit Court have done is go beyond the meaning of the statute, and they're trying to legislate from the bench. And that is wrong. Am I...
I guess field preemption is a doctrine of interpretation. I'm not, the problem I'm having is I don't read the statute and find a plain, clear meaning that it incorporates a restriction on the school districts. And then I look at the Senate bill that was introduced. They're trying to make that clear. Now, that's not an indication that they left it out. Maybe there's a belt and suspenders type approach, and they want to make sure that the intention is clear given the case law that's come out of the Court of Appeals. But I hear you arguing two different things. You want us to apply the plain language of the statute and give it a reasonable construction, but by the same token, you're asking us to take all of this and impose upon the statutes this doctrine of field preemption, where perhaps what really is an argument of better support is the conflict preemption, as noted by Justice McCormick.
I'm not sure where the question was, Your Honor.
I'm not sure that when I read the statute, I get the plain reading you're giving us.
Well, I think if you look at the two statutes I've cited, 237A and 425O, I think it's quite clear. A Gun-Free School Zones Act does not apply to A with a concealed pistol license. So that's completely off the table. So now we look at 425O where you can carry. And a parent is allowed to carry in the, it lists where you can carry concealed. It doesn't address that you can't carry, it says where you can't carry a concealed firearm. Nothing about that means unconcealed carry.
Okay.
I think I'm out of time.
Any further questions? Okay, thank you very much.
Thank you, Your Honors.
Thank you, Your Honors. William Blaha from Collins and Blaha, and it's an honor to appear before you today, the highest court in the land, on such an important topic about guns in schools. It's also an honor to be representing the Ann Arbor Public Schools, its Board of Education, Superintendent Dr. Swift, along with co-counsel David Komsa and Julia Melkich, and the 17,000 plus students who are educated by that school district. The issue from our perspective, I know the preemption is what is at task, but it's a narrow issue in terms of the population who wants to open carry. School districts are already prohibit the students from having weapons on school grounds. Employees can't have weapons on school grounds. And the federal gun-free school zone prohibits weapons within 1,000 feet of school unless licensed by the state. The only licensing that the state of Michigan does is concealed pistol carry. And when you look at the penal code combined with the firearms statute, the Concealed Pistol Zone Act, that the concealed carry is even prohibited with the exception of certain exceptions. So schools have been carved out to be particularly safety-sensitive zones as declared by Justice Scalia and Heller decision. And so we are limited only to visitors, and the open carry is what's at issue. And so the plain text of the statute, it's a partial preemption from our perspective. It's not a exclusive across-the-board perspective. The plain language does not include schools. We know by looking at other statutes that school districts are included when the legislature so intends to include schools as part of the local definition of government. And there's no conflict between the policies that the Ann Arbor Public Schools adopted with any state law.
Can I cut to the quick, counsel, at least from this justice's perspective? A provision that was not mentioned at all by Mr. Makowski is MCL 380.11A3, which basically is part of the school code and specifically says that the rights and the powers that can be exercised by school districts in the state of Michigan are broad. They're related to the educational mission, obviously. They can include safety and security matters, as arguably would implicate the accessibility of firearms. But it proceeds to say that all these authorities are except as otherwise provided by law. Then I look at 750.237A, which Mr. Makowski did cite, and it says that an individual licensed by this state or another state to carry a concealed weapon is accepted from the general prohibitions upon gun ownership and possession in weapon-free school zones. Why is that not the end of the analysis? Not just the beginning, but why is that not the end of the analysis?
Well, and when you look at the statutes in peri materia, weapons-free school zones is the first doctrine, combined with very few exceptions. Firearms in a trunk or a parent in their vehicle that has a concealed pistol license. So one view is the legislature has already prohibited open carry on school grounds because it's limited to vehicle and only for specific purposes.
You're talking about a different provision. I'm talking specifically about 237.A. I'm not asking this question like I know that the answer I'm suggesting to you is right, but I mean, I'd be interested in your answer. Why is this not specifically the otherwise provided by law provision?
I'm sorry, could you please reread the second one, not the school code provision, but
750.237A?
yeah.
It says, an individual who possesses a weapon in a weapon-free zone is guilty of a misdemeanor.
Yes.
Then it goes on to list categories of individuals who are accepted, who are excluded from that provision, and Section 5C says one such category accepted are individuals licensed by this state or another state to carry a concealed weapon. It seems to me the only logical implication from that, and I could be wrong, but the most likely and logical implication is that such individuals can indeed carry weapons in a gun-free zone.
The
issue here is not the wisdom of the policy. It's not whether we should have guns available here and not available there. The mission, as Justice Bernstein indicated, is to construe the statute as faithfully as we can.
Sure.
And I'm trying to understand why, where the principal authority belonging to schools is defined in the school code with the proviso that unless there is some other law that allows individuals to carry guns in school in weapon-free zones, it can't be done. And I'm suggesting, or at least asking, why this is not precisely the other law that effectively removes from the school districts the authority to tell CPL or CCW owners that they can't possess a firearm in a weapon-free zone.
Right. So I think you, Justice Markman, are hitting a very significant heart of the issue. When you look at the except as provided by the law for license, et cetera, right? Then you go to another aspect of the law, which is if you're licensed, you cannot concealed carry. And to me, what the issue about whether you can open carry is put out by the state police and everybody else that's neither prohibited or permitted, and to open carry on school grounds, and consequently you have an issue if it's not expressly permitted or prohibited, whether the school code allows for a local school board to close that loophole under the rights of it has under the school code.
I think the school code clearly allows schools to enact rules and regulations pertaining to school safety and security matters. I don't doubt for a second that that language is broad enough to encompass rules and regulations concerning weapons. But all the authority given to schools under the school code is conditioned or limited by the existence of a contrary statute enacted by the legislature. And my question again is a simple one. Why is not that provision in 237A that contrary statute?
Because I think if you just narrowly look at that without the full context of reading the statutes and the intent of the legislature, which is weapons-free school zone.
You may well be right, but what is that context you're referring to?
The repetitive statements, both at the federal and the state level, about a weapon-free school zone. And I would urge reading what the amicus brief in the negligent state bar section.
I'd rather read what the legislature has done.
And when you look at the plain language of those statutes, it is not clear that the legislature intended for open carry on schools. In fact, it's the opposite.
I think this is related. I think the Chief Justice's question is related to a question I was asking for other counsel, and I'd love to hear your thoughts on it. Why isn't it possible that that exception allows the policy of the school district, but the policy doesn't conflict with the state law? So the state law says it's not a crime for for somebody to carry a gun. The policy can still say, but we don't want you on our property if you're doing it, so we have the ability to remove you. it's not a crime. Why is there a conflict? Why isn't it just one's a policy saying we don't want people on our school grounds with guns? We might not want them on chewing gum. I don't know. So we have the right to ask you to leave. We're not saying you're committing a crime. So where's the conflict?
I think that's a great distinction between the criminal aspect that there could be a crime, but there isn't in the instance of a school district's authority and duty to enact rules for the safety and welfare of its students, so that, in essence, the loophole that apparently exists, if that's what's subscribed, there would be no conflict with any state law.
Can I suggest the conflict is precisely that if the legislature's command is to be respected, persons with CCW or CPL permits have the authority to be on school property with a weapon. However, if the school district somehow has the authority to say, no, that's not going to be something that's going to be permissible in school areas because we regulate those areas, that person who yesterday could go into the school area with a weapon can't do it on the next day. The conflict is the state has said you can go onto school property if you qualify, if you have a permit. The school has said, no, you can't. That seems like a pretty direct conflict to me.
I don't know how the court gets around the same precept then.
I'm sorry?
The court. If the court allows, or if the court, the same exception I understand applies for a court. And so if then the court issues an order that says no weapons are allowed, it's the same conflict then that the school district would, that you're asserting that the school district has.
Well, who prevails if there's a conflict? I agree there's a conflict. That's the whole point. Who prevails if there's a conflict?
So I think we need to go back to the fact that the legislature did not specify schools as something that would be preempted, and that in all instances weapons could be carried, just like with the court system, that they don't have the exclusive authority to determine that they can preempt anything and everything at all times. They preempted 4 entities. Local unit of government specifically defined, but not the schools, not the courts, not the banks, not the daycare centers, the churches, etc.
There's an explicit prohibition in the law against people having firearms in school zones. There is, however, an exception that's equally broad, and that says that licensed individuals have the authority to carry a concealed weapon. Again, I don't mean to be flippant about this, but I don't understand why that isn't perhaps the beginning, the middle, and even perhaps conceivably the end of the argument.
It's I understand your view, but we are proposing an alternative plain language analysis, because concealed carry, just because you have a license, that's also prohibited on school grounds.
Where is the authority then? Tell me specifically, instead of just talking generally about context or policy, where specifically do schools, Ann Arbor, other school districts, where do they derive their authority from to overcome what appears to be the command of 237.A? Just tell me where the authority comes from. That's all I want to know.
There's a myriad of authority. Heller, the Federal Gun-Free School Zone Act, the school code.
Heller provides
that the ability for regulation, that the Second Amendment rights are not sacrosanct, and that
well, I agree. I think that's an accurate characterization of Heller, but where has the state of Michigan taken advantage of the regulatory authority that Heller seems to confer upon
well, we know that there are
state authorities,
that there are numerous statutes addressing this point, but that it has not been determined to be all-encompassing in terms of state preemption, and that statutory provision that you're focusing on, when you combine it with what we believe to be the intent of the legislature, that the school district would have the authority under the school code to address weapons on school grounds in the open carry instance.
I'll cease after this question, but the only authority that I can clearly see, the only indisputable authority that the Ann Arbor School District has to regulate firearms derives from the school code. The problem with that, it seems to me from your perspective, however, is that there's an asterisk at the end of that that says, provided, however, that there is no contrary law. And once again, I'm asking why that contrary law isn't exactly what I quoted from, stemming from 237A.
I understand your question, Justice Markman. The legislative intent, we believe, is weapon-free school zone, and that provision does not apply across the board, including the courts and the other entities. You have the powers, like the school district would have, to regulate accordingly.
Council, schools are responsible for the health and safety of those who attend. Is that correct? That's part of the emphasis that we've been putting forth?
That's correct, Justice Bernstein.
And I guess my question would be, is that if a person were to come onto a school property and have a weapon with them, and under the law, we're talking about a weapon that can't be concealed and is open for, public to see. When you're dealing with the health and safety question of the students, what would the school policy be at that time? If an individual were to come on to school grounds or school property and the weapon is visible as it's required, would the school have to go into a firearms, whatever I believe there's a specific expression that they use, an active shooter drill, or would the school have to take some type of action, if a person enters the campus? How would the policy be to address that?
So, and I see my time.
That's okay. You can. The good thing about being judges is we can let you go over. So.
Thank you. So 2 points. One is I'm addressing the Ann Arbor policy, because what we also are advocating here, like some of the amicus briefs, is letting local school boards decide in the state of Michigan that some schools would view this differently than the Ann Arbor schools, but in the Ann Arbor schools, what they've adopted is that the presence of a weapon on school grounds constitutes an emergency as set forth by the Michigan Department of Education. And so then there would be the attendant consequences of a lockdown and shelter in place, et cetera, which in and of itself is disruptive. And so there is, on that basis, that's what the Ann Arbor policies.
So the policy would then, just so I understand correctly, the policy would be as if, a lawful gun owner came onto the property, that the school would have to initiate all of these emergency procedures. That would be the policy of the school district.
That's correct, because we don't, even when you check, and this is why we can get different in a setting like Ann Arbor compared to perhaps in a rural setting where the police are 30 minutes away and they know the individuals in the community. But in the Ann Arbor setting, they don't know who everybody is, and they don't know what the intent is of an individual on any given day, even if they did know, and so their policies are such to engage in the protection of students and the lockdown processes, et cetera, which is disruptive.
Thank you, Council.
Thank you.
Any further questions? Thank you very much, Counsel.
Thank you.
I'm afraid your time is up. Doesn't seem like 15 minutes is quite enough for a case of this dimension, but we appreciate both of your arguments. They've been helpful, and we'll have a second case that involves essentially the same issue, so we'll hear more about it. Any further questions? Okay, thank you. Your case will be submitted.